Hi, everybody. Welcome to another episode of Logically Speaking. I apologize for looking down. I am checking the live stream to make sure that I'm up and running this time. But on today's Logically Speaking, we are going to be continuing our series on the overview of criminal cases. What we're looking at today, so our previous one, we did an overview in general of a criminal case from start to finish, what the overview procedure is, and a general time frame. Today, we're going to break that down into even a smaller bit. And we're at the first stage is arresting someone and then formal charges on someone. So today we're looking at arrest versus formal charges. What's the difference between the two and how long does it take from arrest to formal charges, and what's the time frames? And I often hear people call my office after they've been arrested to say, help, I've been charged with such and such a crime. And that's not completely accurate, but you're not totally wrong, but it's not completely accurate because at that point in time, you've been arrested for certain charges. You haven't been charged with those crimes that you've been arrested for yet. So initially, law enforcement arrest you for the probable cause for the crimes that they feel they had probable cause for, which is a very low burden, a very low standard that for law enforcement. Probable causes are lowest standard inside the criminal justice system. Actually, reasonable suspicions right below that, but that's for different things. But probable causes are lowest inside of our criminal justice system for what we need. And it's not hard to get there. It's not hard to meet it. And they arrest you. They arrest you for the highest possible charges that they believe are the highest possible crimes that they believe they have probable cause for. Now, that may or may not be ultimately what you are actually charged with when it comes to formal charges in court and what happens there. So law enforcement then develops probable cause. They arrest you, again, for the highest possible crimes that they feel that they have probable cause for. And you're arrested. You go, either you bond out, or you'll get a bond upon your arrest per bond schedules in certain counties. If it's a case that, or a charge that does not allow for a bond per statute, and then you have to wait to see the judge. You are required to see a judge again within 24 hours of your arrest if you don't bond out. And that does apply here in Florida, even on holidays and weekends. You are still required to see a judge within 24 hours. You won't have to wait until Monday or until the holiday is over. There's always a duty judge that is scheduled to be there, and they will see you within 24 hours. If you have a bond set per that bond schedule and you haven't bonded out yet, the judge will address your bond to determine whether they will leave it the same or raise it or lower it based on certain circumstances, and how much that bond will be, and then any conditions of your bond release, if they're going to put any other conditions on there, such as no contact with someone or a GPS monitoring, or whether it's going to be supervised release or unsupervised release and what the terms of those mean. Or it can just be a straight cash bond, or where you have to pay a bondsman for a bond without any other type of conditions on there. And if it's a crime that does not allow for a bond upon initial arrest, then the court or the judge will then address that particular charge and will determine whether you're entitled to a bond, and then set that bond based on the statutory factors, and as well as the bond schedule and any other conditions that are brought to the court at that point in time to address bond. That is at this time the only thing that is addressed. That's what we call first appearance court. Typically, it's your first appearance before a judge after you've been arrested, where the judge is going to determine your bond amount, again, within that 24 hours of your arrest. If you haven't bonded out already, that's what we call first appearance court. And that is the only thing that gets addressed at that hearing. There isn't anything else that's addressed. You don't get to argue your case. You don't get to ask for a dismissal. You don't get to, some judges for some minor charges might accept a quick plea to resolve it and be done with it. But that's not generally the rule of what happens. That's the exception to what happens. But certainly on any more significant things, that does not happen. Those are really only for some minor criminal traffic offenses or things like that, that might be something that happens at that point in time. But generally, the only thing that happens there is addressing your bond amount, and your bond conditions for release. And then if you bond out, that flags certain timeframes, versus if you don't bond out, there are certain timeframes that go into effect. So let's first talk about if you do not bond out. So if you are not able to bond out and you are staying in custody, for some reason why either you weren't entitled to a bond and didn't get a bond, or maybe at that point in time the bond is too high and you can't afford a bond, or there's nobody outside that you can reach to pay your bond, but you don't bond out, then the time frame kicks in for the state to file formal charges against you. The state then does their investigation to make what their formal charging decision, and they have, while you're sitting in custody, 30 days to charge you while you're in custody. That can be extended up to 33 days and can be upon good cause, sometimes even a little bit longer than that. They have 30 days to charge you. If they don't charge you while you're in custody within that 30 days, then you have the right to be released from custody. That doesn't mean that your charges get dismissed. It doesn't mean your case is going away. It just means that if they haven't charged you within that 30 days, up to 33 days with good cause shown, that you have to be released from custody at that point. And that's done by a motion that has to get filed either by, if you're not represented yet, by an attorney, but most people who are in custody are represented by at least the public defender's office at that point, and there will be a motion filed for your mandatory release because the state had not formally charged you within those 30 days up to 33 days. And so that's the time frame if you do not bond out, if you're still sitting in custody. If you've bonded out, those time frames are extended for a significant amount of time. The minimum amount of time for a misdemeanor is 90 days, and that's the speedy trial time frame. But the state technically can have, depending on what happened and some things with that, can have up to the statute of limitations time to charge you. And for felonies, the speedy trial time is 180 days, up to sometimes 2 years, 3 years to 5 years, depending on the statute of limitations time to file charges. So what does filing charges mean? Well, there's a couple of different ways that charges get formally charged against somebody who's been arrested. One is by information, the charging document that the state files that tells someone what they're being charged with formally by the state is called an information. The state attorney who is tasked with the intake or with doing the investigation on that case makes the decision on what charges to file, and they complete their information, they sign it, it's notarized, and they sign it and file it, and that is formally charging you. And then that creates timeframes that we'll talk about in the next video of what happens after formal charges. I'm not going to go down that road right now, but that starts the next section of what happens inside your criminal case and the timeframes there. The state can use, if it's a criminal traffic, for instance, if you've been arrested for a DUI or driving on suspended license or one of those other criminal traffic type of charges, your citation that law enforcement writes can be the charging document. For certain misdemeanors, law enforcement can write you a notice to appear, and you will actually never be arrested in that particular case because in lieu of arresting you, law enforcement issues you a notice to appear. And that is your charging document and what you have to go to court with. And the state can use that as your formal charging document. Many times they still file that extra step of an information in those misdemeanor cases, but they don't have to. That notice to appear can be your charging document as well. And then the only other way is by indictment by the grand jury, and that in Florida is reserved for our capital cases, like capital murder, the death penalty type of cases that go through the grand jury for indictment. So that's the 4 ways that the state formally charges you. Those formal charge documents, the indictment, the information, what those do is they alert the defendant in a criminal case of what the state is charging you with. That's it. That's what it's for. It's not evidence against you. It doesn't have any other significance other than to tell you what they're charging you with, what crimes they're accusing you of committing, under what statute they're accusing you of committing, and then what level of crime it is often referenced inside of that charging document. So that is arrest versus formal charges. What is the difference of them? And then those time frames from arrest to formal charging, how long the state has to formally charge you. I hope that answered at least some questions in that avenue of criminal cases. We will talk in our next video on criminal cases, on the overview of a criminal case, what happens after formal charges, and the next stage of a criminal case after formal charges, which we get to in arraignment. We'll talk about that in our next video. So if you or someone you know is going through a a case inside the criminal justice system and you'd like to speak to us, please feel free to give us a call and we'll be happy to talk with you. We'll see you on the next video.